Assalamu alaikum, good morning everyone. Today's seminar is on tort law and corporate accountability. Sorry. Now, corporate accountability is an imperative in any society which professes to be governed by the rule of law. If the fundamental rights of citizens are allowed to be sacrificed in the pursuit of profits, economic inequality comes to the fore and social justice has to take a back seat. Now, tort law has the potential to rein in these corporate excesses by holding hospitals and clinics accountable in cases of medical negligence, by requiring owners of vehicles to compensate victims of motor accidents, by requiring manufacturers to pay damages where a defective product causes injury to the consumers, and by holding employers vicariously liable in respect of workplace harassment. Now, we will discuss some of these issues today. And we'll start off with a keynote paper presentation by Mr. Nabil Ahsan. Mr. Nabil Ahsan, I've known him for the last 10 years, and he is a very, very bright lawyer, and unlike many other lawyers, he has many other interests. So he's an avid photographer, he's a filmmaker, and he also reviews perfumes. And he has other interests which we shall not discuss here. I had mediation in mind. He is an accredited mediator at BIAC. So without further ado, may I invite Mr. Nabil Ahsan to come to the stage and place his keynote paper.
কাজ করে Thank you, Mr. Siddiq, for that interesting introduction. And esteemed members of the corporate community and the legal fraternity, a very good morning to you all. So we'll be discussing about tort and corporate accountability. Now, this first photograph, you must have seen it. This went wild in the social media a couple of weeks back. This is Rajib, but precisely his hand caught between two buses when two buses were rampaging in a mad race. He lost his hand. In a couple of days, he died. The Facebook community, the social media, the newspapers went wild. These bus drivers are unreasonable. Punishment should be increased. They should be hanged, this and that. And then we forgot him in 2 weeks' time. Something new happened. Another lady lost her leg a week back, and she died, and we're now talking about that. Rajib is forgotten from our memories, but Rajib remains very much alive in the memories of the siblings he left behind, his father, his mother. He was a potential bread earner, and they will remember him for a long, long time. We may forget him. This is a famous photograph from the Rana Plaza incident. The photographer was a young female at that point of time, relatively unknown. And she won many international awards for this particular photograph. I remember her. I know her personally. I do not know who these characters are in this photograph. I do not know this man. I don't know this woman. I don't know how many children or siblings he left behind. He is forgotten. But these siblings and their family were dependent on him, and I don't know where they are right now. And this is Jihad again, a very sensational case. So this brings to the area of tort, which is somehow at the backstage right now. We talk about criminal liability, we talk about a lot of things, but we don't talk about compensation to the victims or their families. Now, essentially, tort is an evolution, or it evolved from the law of contracts, particularly in the US. Principles of the contract was extended to develop tort, and the origins can be rooted to common law. And always, particularly in the US perspective, there was a competition between the interest of the industry owners or the capitalists and the interest of the workers or the citizens. And the court had to maintain a fine balance, because in a developing economy, you can't have courts intervening too much that will affect business. At the same time, the rights of the citizens or the rights of the workers have to be protected. So in the US, it evolved into a a very friendly, tort-friendly nation, while some European nations are less tort-friendly. In Bangladesh, for instance, we are very much unaware of what tort is and how to proceed. So it's a process of evolution. Now, negligence is a big part of tort. When you talk about tort, there's tort of defamation, there are other torts, tort of nuisance, but negligence is probably the most important aspect of a tort and probably the most important and relevant for our context. Donoghue versus Stevenson was the starting point of negligence principle in the United Kingdom or in the English jurisdiction. The issue was there need not be any contractual connection with the victim. All that is necessary is a duty of care. I'm sure all law students, all lawyers have read it in their first year, and the courts also know it. There's no reason to go into the principle itself. But what happened is in England and in America, where duty of care exists, where it doesn't, develop through case laws gradually. In Bangladesh, we do not see much discussion or much decisions on negligence as such, and we do not really know, or it hasn't developed through the common law as such. That brings me to the next point. There is no particular legislation dealing with tort law and or remedies. As I said, tort law is essentially a common law principle. And in other jurisdictions, through case law, it evolved, and in the clear parameters of torts were defined. Here in Bangladesh, we have nothing. So if a question is asked, does tort law exist in Bangladesh? The inevitable answer would be yes. But how, where, to what extent, what's the procedure? These questions, to a large extent, remain unanswered, and I hope the panelists today would bring this into the fore, and this will be clarified. Tortious negligence principle is recognized by our courts, yes. But very rarely we see that being dealt with in cases. Now, the next question is, why there are so few tort cases? What's the reason? The most obvious answer would be, the most logical answer would be the long-drawn process and procedural complexities of filing and contesting a civil suit. I give an example here. The Bangladesh Beverage Industries versus Roshan Akhtar case. Now here, a journalist was killed in a motor accident in 1989. Eventually, the Apex Court awarded him compensation in the region of 1 crore 70 lakh, and this was in 2016. And to my knowledge, the family did not till date receive the amount. It's an execution case is pending. So how many years has it been? 30 years. The reason for the compensation was for the children and the family to sustain a decent living that occurred due to the loss, sudden loss of the father or the husband. After 30 years, what use is that money? So, of course, procedural delays is one of the reasons. And to explore further, victims and families are apathetic towards legal remedies. This is a litigation culture to some extent. We always talk about criminal justice, hang them, more punishment, no bail, things like that. But discussions on compensation or tort always, for some reason, takes a backseat. So, and the victims and their families also are grieved. Perhaps we are a fatalist society. We talk about whatever happened, what can we do about it, let it go, but we don't talk about compensation. Lawyers and victims alike may be unaware about the appropriate procedure. This can be very much true. If you haven't dealt with tort before as a lawyer, you might have certain confusions, and as litigants, you simply don't know where to go for compensation. Another interesting point is apathy exists irrespective of financial standing of victims. So, motor accidents, for instance. Rich people die every day. So, but how many motor accident compensation claims do we have? So, it's just not a fact that because people don't have money, we don't have these cases, so we need legal aid. It goes beyond that. Simply the culture of seeking compensation is missing. So the point can be made at this point that do we need a law or a statutory framework for tort in Bangladesh? We need not define the substantive law of what negligence is, but certainly the procedural aspect of it may come and be clarified through a statute. Our panelists would perhaps comment on that and elaborate. Because we don't have torts coming in through the regular forum, what we see is judicial activism in the form of constitutional torts, and we are seeing a lot of them. Many judges are being activist in this respect. The jihad case is a good example. Jihad, in this case, the boy was trapped in a tunnel for a number of hours and died. The question was, this tunnel belonged to the railway authority and they should have kept it safe. They didn't. And the boy died as a result. In this case, Madam Justice Farah Mahbub brought out an interesting point. She said, basically, constitutional torts are effective in some instances where the fact in issue are beyond dispute. For instance, here she said, she brought in the res ispa loquitur doctrine, that is, the thing speaks for itself. So there wasn't much dispute who is at fault here. So constitutional torts can be the perfect remedy for this kind of scenario. But constitutional torts cannot be a remedy where the facts are in dispute, where you need evidence. So constitutional torts has its limits. It is an exception rather than the norm for pursuing tort remedies. I will skip this one because I've discussed it. Let's move on to something very specific, that is road accidents. At least 4,284 people died in 2017. That is a large number. That is a large number. In every Eid, when I open the newspapers, 15, 20, 25 people die every year. And it's happening all the time. And it's very easy to file a compensation claim under the Motor Vehicle Ordinance. But we don't see that. But that is something I'll discuss later. The point I want to raise is compensation. So how much do I deserve for an accident? There is no guideline in regard compensation payable for death or injury to the victim. In most of the judgments I've come across, basically the courts refer to this decision in 22 DLR, and they refer to this quote. Assessment of damages in such a case must therefore necessarily be, to some extent, of a rough and approximate nature, based more or less on guesswork. For it may be impossible to accurately determine the loss which has been sustained by the death of the husband, wife, parent, or child. No definite hard and fast rule can as such be laid down as to the matters which should be taken into account, but this much can be said, that only such damages can be given as can be shown to have been financially suffered by those who bring the action. In estimating such damages, the court will no doubt take into account the age of the deceased, his or her health, earning capacity, and even the chances of advancement. There may, however, be evidence of reasonable expectation of pecuniary advantage and not a mere speculative possibility. That's a lot of things to consider. I'll bring into consideration the English example. So a lot of us here may be barristers, and you may have trained yourself recently as a BVC or BPTC student, and you will have dealt with Ogden table in your civil litigation courses, where we do complex mathematical calculation to determine the exact quantum of damages that is payable. And that guideline is published by the Law Commission. So what that does is brings in consistency to the system. The claimant, before going to the claim, can assess that this is what I'm going to get. The judges know on what basis to issue award damages. So that is also one of the things we should consider, the pros and cons of having judicial guidelines or statutory guidelines on compensation. Another area or large area is maritime disasters and large-scale industrial accidents. Rana Plaza, Tazreen Fashion, we all have seen the photos. We all talk about it from time to time. That comes into mind. And also maritime accidents. Every time during the summer, there is a what we call launch or the small ships. There's an accident and hundreds of people dies. The minister comes and says, okay, I donate 10 lakh, 20 lakh, 30 lakh for the burial. But is that it? The burial cost, is that all they deserve? So for this kind of a situation where you have hundreds of people, this is not a typical case where a claimant comes before the courts and files a case. We do not know how many victims there are, and finding their families would be a struggle. So in US jurisdiction, what we for instance have is class action suits, where one person comes and files the case, others may join, others may not join. Ultimately, whatever damage is recovered in that case is distributed between the parties. So far as I understand our civil procedure, class action suit as such is not clearly defined, and we can consider this as something to think upon, to reflect upon, to provide for procedures where class action suits may be introduced, because that will be a solution for this kind of a large industry, large-scale disasters. And not to mention the issue of excessive court fees. So if you have to file a case of tort, basically it's a money suit, and you have to provide a court fee. And if you are, say, claiming 1 crore taka, you will have to pay maximum court fee of 57,000 taka, which is a lot of money. For a lot of these victims, they are now homeless or have other financial difficulties. Paying 57,000 taka court fee is a big issue. So, for instance, under the motor vehicle ordinance, you do not need such high court fee. The court fee is, I think, only 120 taka. So, can we introduce something like that for tortious claims? The court fee can be reconsidered, or class action suits where this will be taken into account. I'll not discuss contingent legal fee. I'll move on. Okay. I now want to move on to the issue of medical negligence. Once again, so far as our law is concerned, there is no specific provision for obtaining medical compensation in medical negligence claims. What we have is the use of our penal code particular sections. And again, once again, as I said, we are always about jailing the victim and putting him behind bars. That's what we are concerned about, not necessarily finding compensation. But again, as a form of judicial activism, we have seen certain constitutional torts. There was this recent suo motu rule issued by the High Court where compensation of taka 3 lakh was given for a botched C-section. Basically, there was a gauge inserted inside the body of the woman, and it was left like that. And the High Court issued 3 lakh taka as compensation to the victim. And I'm happy to mention that our moderator here, Mr. Imran Siddiq, happened to represent the victim in that case. So bravo to you, sir. We also have one of the examples of death of Dr. Mridul Kanti Chakraborty. Here, 50 lakh taka fine was given to LabAid for negligence in operating in due time. So we have these instances of constitutional torts, but what we are missing is a consistent body of jurisprudence that will give consistency to the system, and people will know what to do, when to do, how to do. Am I running out of time? With your permission, can I finish it, right? At this point, I'll raise the question whether the Consumer Protection Act 2009 could be considered as a forum for filing medical negligence claims. This is a new law, and it is being used for a lot of consumer disputes. I'll bring into account the Indian experience here. In India, the Supreme Court held that the Consumer Protection Forum there, under their act, can actually be used for medical negligence claims, particularly the issue of service, whether the service provided by a medical professional falls under the definition of their act. And the court said yes. So cases are actually being filed. I have statistics here. So we don't see too many cases. So 15 cases were filed, and in 31.25% of the cases, the claimant or the victim was able to prove his case. In 68% of the cases, he was not. This brings to the next question, that medical negligence is a very specialized issue. Whether there was negligence or not cannot simply be determined by lay people. You need some expertise on that. So the US example would be a good one. In US, in some states, they have specialized tribunals comprising of legal personnel as well as medical professionals. So the cases go before them at first, and if they are found to be frivolous without merit, they are immediately thrown out. So that is something we can consider. Vicarious liability of the hospitals and mandatory insurance of doctors. I'll skip this for now. I move to the next topic, that is sexual harassment at workplace. Now this is again, so far as sexual harassment is concerned, we do not have specific laws. Yes, the Nari Nirjaton Domon Ain deals with more grievous offenses, particularly sexual oppression, but sexual harassment is somehow without without statutory guideline. But we had this interesting case, Bangladesh National Women's Lawyer Association versus Bangladesh. Here, what we had is a specific guideline from the Supreme Court, where basically there was a direction on all workplace and educational institutes to have in place a complaint committee so that the victim can complain and a proper course of action will be taken. So that's a very positive step. Interestingly, the guideline does not provide any scope for compensating the victim. I'll again draw an analogy with the Indian scenario. In India, we have the Sexual Harassment of Women at Workplace, 2013 Act, which has similar guidelines as well, which has similar provisions to have a complaint committee in place at every workplace. But additionally, Section 13 and 15 actually provides a scheme for providing compensation to the victims. So that's something we need to consider as well. Now, this is an interesting case. British American Tobacco versus Begum Shamsun Nahar. This is actually, the case is ongoing. Here, the claimant filed a suit for sexual harassment and wrongful termination, claiming damages in the amount of taka 2 crore. That's a big case. She was discharged from service in 2013, and she filed this claim in 2004. Now this is pending before the district judge. So we have to wait what is the outcome. But this is a precedent to show that you can actually go to the courts and file a case for sexual harassment. Nari Nirjatan Daman Ain again has a provision, Section 15, where the court can award, where the court has discretion to award compensation for cases. But again, the wording is Jouno Nipiron, that is oppression and not sexual harassment. And even if it is considered as harassment, the power is discretionary. The power is not mandatory. So that's something. Last issue I want to touch upon is rape cases, and we see in the paper every day rape inside buses and rape at different places. Of course, vicarious liability, whether the victim, other than, we are all saying let's frame a law to hang them and all this and that. That's good, that's fine, that's all right. But what about the compensation to the victim? She may suffer irreparable mental injuries for her life. Her work might suffer. So you need compensation for that, and we need to consider that as well. So in England, for instance, we have the Criminal Injuries Compensation Authority, where a victim actually goes, and that authority has power to provide compensation to the victims. The authority tries to recover the amount from the rapist or the person doing the sexual oppression. If it's not possible, then it comes right out of the fund of the government. So we can also consider having something like that in place. I think my time is up and I've already crossed it. So that will be all from my end. Thank you very much.
Thank you, Nabil Ahsan, for that presentation. It was very succinct, yet comprehensive. In order to discuss the issues raised in the